In March of 1970, two attorneys filed a lawsuit in U.S. federal court on behalf of Norma McCorvey, a Texas resident. She wanted to terminate her pregnancy. That filing, Jane Roe v. Wade, argued that Texas's abortion statutes were unconstitutional and violated her privacy under 5 constitutional amendments. In January 1973, a 7-2 Supreme Court decision in favor of Jane Roe. That rules that the Constitution protects the right to an abortion. The all-male justices found abortion was, quote, a fundamental right for a woman's life and future. September 1976, the Hyde Amendment, a restrictive measure prohibiting government funds to be spent on abortions except in the case of rape, incest, or threat of life to the woman. That measure is passed. Then, in 1988 and 89, lawmakers in Pennsylvania amend the state's Abortion Control Act of 1982. By doing so, they added 5 provisions that included informed consent before an abortion, a 24-hour waiting period, consent of one parent for a minor to have that procedure, and a husband notification requirement for married women. In June of 1992, Planned Parenthood of Southeastern Pennsylvania versus Casey. The Supreme Court's 5-4 decision upholds 3 of the provisions. The court did invalidate that husband notification requirement. November 2003, President George W. Bush signs into law the Partial Birth Abortion Ban Act, prohibiting doctors from performing late-term abortions. April 2007, the Supreme Court upholds the federal ban on late-term abortions, ruling 5-4 in the Gonzalez versus Carhart case, finding that it was not unconstitutionally vague and did not impose an undue burden on the right to abortion. July 2013, Texas lawmakers enact what's called House Bill 2, with provisions that include requiring doctors performing abortions to have hospital admitting privileges no more than 30 miles from the abortion facility. Abortion providers in Texas then challenge the requirements, arguing that they violate the 14th Amendment under Casey. This challenge ultimately ends up before the Supreme Court and is struck down in June of 2016. Also in June of that year, the Texas Admitting Privileges and Surgical Center Requirements law is struck down. That's done by the Supreme Court in a ruling that was 5-3. Fast forward to May of 2021. The High Court agreed to hear Dobbs versus Jackson's Women's Health Organization case. It's the Mississippi law that bars abortions after 15 weeks of pregnancy. Later, Mississippi state officials would ask the Supreme Court to overturn Roe and Casey. September 2021. Texas enacts Senate Bill 8, or what's called the Heartbeat Act, the first time a state successfully imposed a 6-week abortion ban since Roe v. Wade. The act also gave members of the public versus state officials the right to sue anyone who performs or helps facilitate an illegal abortion. The Department of Justice then challenges SB 8, and in December, the Supreme Court ruled to keep Texas's ban on most abortions in place, limiting who can sue state officials. And all that is what brought us up to last month, when there was that 98-page draft opinion in the Mississippi abortion case that was linked, hinting that the Supreme Court was likely to overturn Roe v. Wade. That's exactly what's happened today.